All right, welcome everybody. Still in this virtual world of ours. We're doing a presentation today as part of the BCBA series on legal issues arising out of the Marshall Fire. I am Marshall Gilinksy, no relation to the fire. I'm a partner at Anderson Kill. With me today is Carrie, DiCanio, who's also a partner. She's managing partner of the Denver office at Anderson Kill. We both work in the insurance recovery group at the firm. There's about 40 or 50 lawyers in that group who specialize in representing policyholders and only policyholders in disputed insurance claims, assisting our clients in maximizing and obtaining recovery on complicated insurance claims, usually property and casualty, commercial insurance claims, but all kinds. For about 20, I've been working at the firm for about 25 years. And ever since 9/11, mostly, I've had a tremendous amount of experience working on disputed property insurance claims. So I'm happy to be here today to share with you a fairly focused range of insights about the types of issues that are apt to arise with respect to fire insurance losses. The focus probably on a bit, from a business insurance perspective, but also a lot of these principles equally apply to the homeowner's context. So hopefully this will be for you of great use to a lot of you who are assisting clients, as whether it be individuals or businesses responding to and recovering from that terrible wildfire last month. So let me introduce Carrie DiCanio. Like I said, Carrie has been with Anderson Kill for, I don't know, Carrie, you tell me, 20 years as well, almost?
Almost.
She's a genius and a wonderful friend and colleague. She moved with her family to Evergreen about a year ago, and she is now the managing partner of Anderson Kill's Denver office. So Carrie will kick us off, and we'll start to talk about property insurance and recovery issues.
Thank you. Thanks, Marshall. Just to briefly go over what we hope to cover during our presentation. First, we have the following 6 learning objectives. First, we'll discuss the background of the Marshall Fire and insurance law in Colorado. Then how to read and analyze an insurance policy. Notice and time periods that policyholders should be aware of, policyholders who have fire damage claims. Emergency and temporary repairs, documentation of the loss, and preparing and presenting your insurance claim. Just a little bit of background on the Marshall Fire and insurance. This, as most of us know, was the most devastating fire in Colorado history. More than 1,000 residential and commercial structures were damaged or destroyed in the fire. And Karen Clark and company estimate that the insured losses from the fire are likely to approach $1 billion. The Colorado Division of Insurance, as you would expect, has been focused on assisting policyholders in the aftermath of the fire. They issued Insurance Bulletin B 5.43, which is applicable to homeowners insurance policies. And that bulletin provided guidance to insurance companies on a number of issues that arise from fire-related loss, and particularly the Marshall Fire, which occurred very late in the season and during freezing temperatures. That bulletin, to summarize some of the important points, said that if a fire damaged home suffers additional damage due to frozen pipes, water damage, or other water-related damage, all of that damage should be treated as one occurrence, and one deductible should be applied, as opposed to multiple deductibles applying to the damage from the fire versus water. And also advised insurance companies to waive waiting periods related to additional living expense for people who had to evacuate their homes, but their homes were not completely destroyed. They also issued guidance on insurance companies treating damage from smoke and soot and mold as covered under property policies, and advised insurance companies to allow monthly allowances for policyholders who may have moved in with relatives because they were unable to live in their house, but were not necessarily renting a new living space during the period of rebuilding. And briefly, because a lot of what we'll talk about today has to do with insurance policy interpretation, we thought it would be helpful to give you an overview of insurance law in Colorado concerning the rules of insurance policy interpretation. And these are the basic rules that apply. In general, the insurance policy is to be interpreted according to its plain and ordinary meaning and to be read as a whole. And those rules are meant to ensure that the reasonable expectations of the policyholder are met. The reasonable expectations of a policyholder are important when interpreting insurance policies, because insurance policies are often thought of as contracts of adhesion. They're written on standardized forms. The insurance company has greater bargaining power than the policyholder, who often is, particularly when it comes to homeowners insurance, does not have the opportunity to make changes to the policy. They can either accept it or reject the policy. So the reasonable expectations doctrine is meant to protect policyholders who may not be proficient in reading policy forms. Another rule of interpretation is that ambiguities in an insurance policy are to be construed against the insurance company. And what that means is that if a policy is subject to more than one reasonable interpretation, the interpretation that favors the policyholder must be adopted by the court. Another rule is that policy exclusions must be construed against the insurance company in favor of the policyholder. They must be drafted in clear and specific language. And the burden is on the insurance company to prove a policy exclusion applies.
So we'll kind of repeat a little bit of that and just kind of understanding how to make sense of an insurance policy. I think for the next few minutes, we'll talk about that. What do you do when you suffered a loss? How do you understand what coverage you have? How do you understand how much coverage you have, what triggers it, and how a loss is calculated? All that involves reading carefully the terms of the insurance policy, which, as a lot of us know, and as too many people only come to learn in the aftermath of a catastrophe like this, is hard to do. Insurance policies are not Hemingway. They're not short, pithy sentences. They're big, complicated, interreferenced documents that are hard to understand. So we're going to talk a little more about the rules of construction, and then give some advice and tips about how to make the process of understanding what the policy means easier to digest. So kind of following on those rules of construction that are the law of Colorado, they're also the law of most other states as well. It's important to understand the role of insurance in society, because I think that informs why the law is what it is, right? Insurance is designed as a risk-shifting mechanism. No one person can usually afford to have a terrible catastrophe devastate their business or their home or their life. But by paying a relatively small amount of premiums every year to an insurance company, it's a win-win situation whereby the individual or the individual business is protected from the downside risk of a terrible thing happening. And the insurance company, by aggregating a diverse set of risks spread over lots of different people in lots of different places, can have an influx of premiums that they can invest and make a lot of money on. And for those people who suffer losses, have the wherewithal to fully reimburse them for their loss and still have a lot of money left over as a profit, right? It's a risk transfer mechanism. It serves a public good. And because of all of these things, the law tends to protect the individuals who buy and individual businesses who buy this insurance, because that's what it's for. Famously, there's at least famously within the walls of Anderson-Kill, there's a Washington state court decision that announces what should be uncontroversial statement that the purpose of insurance is to insure. It's there to protect the policyholder in the event of the suffering of a loss. And that's why I think we see the tilt of insurance law in Colorado and other places in favor of policyholders. That is, construing ambiguous provisions in favor of the policyholder, interpreting the policy consistent with the policyholder's reasonable expectations, putting the burden of proof on the insurance company who wants to restrict coverage to do so unambiguously and clearly in the terms of their policy. And so that's how, generally speaking, we interpret insurance contracts. That's how courts interpret insurance contracts. And it's good to have those overarching concepts in mind as you sit down with your insurance policy. So let's talk a little bit about the nuts and bolts of what you find when you open the pages of your insurance policy. I think it's on the next slide, Carrie.
Sure. So to give you an overview of the key parts of an insurance policy, what we have is the declarations page. That's typically the first page that you see on the policy. And we'll talk a little bit more after this slide. We'll look a little bit more about what information is contained on the declarations page. And subsequent to the declarations page is the policy itself, which frequently is written in a policy form, but sometimes businesses have manuscript policies, which are unique, bespoke policies. In that policy form, there will be an insuring agreement, which describes the purpose of the insurance and what the policy covers. For example, in a property insurance policy, it would describe that the policy covers all risks of physical loss or damage. That could be an example of an insuring agreement in an all-risk property policy. The policy will contain exclusions, which delineate what risks are not covered or limitations to coverage. And then those exclusions may contain exceptions to the exclusions, which would carve out coverage, even if a certain particular loss may not be covered by an exclusion. There may be an exception to the exclusion in certain circumstances. There are conditions in the insurance policy, which are usually requirements for the policyholder in order to trigger coverage under the policy, such as giving notice of the claim. That's a condition to coverage. There are definitions in the policy. Insurance policies are full of defined terms, and there's often an extensive detailed section of the policy that defines the terms that are used in an insurance policy. A policy often will have endorsements, which modify the form of the policy, and it may modify the exclusions. It may modify other parts of the policy in terms of adding insureds to the policy. And we'll talk in a little bit about how to read endorsements and annotate your policy so that you have a quick reference and an understanding of the entirety of your policy with just looking at the policy one time, after looking at it one time and reading it carefully, of course. The policy will discuss, as I said, who's an insured, and it will provide the limits of insurance. So that's typically the maximum amount that will be paid to the policyholder in the event there's a covered loss. And I mentioned the declarations of the insurance policy before. The information that a policyholder should expect to find on the declarations page of the policy is the information concerning who is the named insured, the policy limits, the policy period. So that's the term during which the policy is in effect. And typically in a policy like a property policy, in order to trigger coverage, the property damage would have to occur during that time period that's specified on the declarations page. There may be a description of the type of business that the named insured is engaged in. For example, if an insured is in the construction business, it may indicate that, or some other type of enterprise. The policy declarations may list the endorsements to the policy, and frequently they will list all of the endorsements to the policy, which is helpful because you can look at the declarations to make sure you have a full copy of your policy. It's important to read the policy in full, including with endorsements. And so the declarations page can be a helpful reference to make sure you do have all of your policy. The policy declarations will specify whether the policy is a renewal of a prior policy. And it may specify if it's a property policy in particular, and there are various locations that are covered by the policy. Those may be listed in the policy declarations.
So when I have a new case that lands on my desk, first thing I'll do is get an understanding for what happened, right? Understand the facts. What's the business? What's the policyholder's business? What do they do? What's the property that's at issue? What are the business continuation interests that are at issue? And what happened, right? Then I'll take out the insurance policy and I'll start to go through these different segments that Carrie just identified, right? I'll look to see what are the coverage grants, what are the extensions of coverage that matter here, and what are the limits that apply for those types of coverage. Then I'll say, look at the exclusions. What are the exclusions, right, that could potentially apply here? What can we expect the insurance company to possibly argue? What won't they argue? And try to get a handle on how much is at stake and what's the right way of taking the losses that are being incurred and putting them into the different limits that are promised in the policy so that the policyholder gets what they're entitled to under the terms of the contract that they bought. So the first step here is looking at the insuring agreement, which are the coverage grants, right? Typically in a property insurance policy, there's two types of policies. Historically, property insurance policies were written on a named peril basis. That is, you'd buy a policy of fire insurance, you would buy a policy of flood insurance, you'd buy a policy for a particular peril. That type of policy is largely out of fashion, and most policies are underwritten these days on an all risks basis. That is, the insurance policy will cover all risks of physical loss or damage, except the ones that are specifically excluded. So it makes it easier to understand what you've got, because basically you've got coverage for all risks of physical loss or damage, which is extremely broad. And then the question is, are there exclusions that narrow the coverage, that might limit the coverage or cap certain amounts of coverage for this loss? And as we said earlier, while the burden is on the policyholder to establish that a claim triggers one of these grants of coverage, it's the insurance company's burden to prove that an exclusion applies and does so unambiguously. So you want to look at the way the policy works and what are the coverage grants at issue, and specifically the extensions of coverage. If you're dealing with a commercial property insurance loss, usually there's a business interruption component, and most commercial property insurance policies have a whole array of extensions of coverage that are added onto the policy to provide all sorts of business interruption coverage. So these types of commercial policies cover not only the cost to rectify the damage that was done to an insured business, but also cover the lost profits that exist that are incurred during the period of time that it takes to repair the damage itself, but also to restore the business to the condition that it was in prior to the loss. It's said generally that business interruption insurance is designed to do for the policyholder what the business had done for the policyholder had no loss occurred. In addition, there's lots of extensions of coverage that are common that don't even require any damage to the policyholder's own property. So, for example, let's say that you operated, a retail business in Boulder County, and in the wake of the fire, even though your business was spared from any specific fire damage, sales fell off for a few weeks while the community was dealing with the direct effects of the fire. You can have coverage under your property insurance policy, business interruption coverage under your property insurance policy under a variety of different extensions of coverage. So, for example, civil authority coverage kicks in where there's damage away from the insured premises that leads to the order of the issuance of an order of civil authority that restricts access to the insured premises. So if travel is suspended and people aren't allowed to move freely around the community and no one's coming to your store because of that, and the order is issued because of direct physical loss or damage somewhere else, there's coverage for that. It's usually capped at 30, 60, or 90 days, but it's a nice extension of coverage. If you have suppliers or customers that are directly impacted by a property insurance loss, even if that loss doesn't affect your business, if you're losing money because of the damage that happened to suppliers or customers, that's something that's often covered under what's called contingent business interruption insurance. Similarly, if there's something that happens away from a premises that restricts ingress to or egress from the insured premises, that's called ingress-egress coverage, also a common extension of coverage in most property insurance policies. So it's important to look at these extensions of coverage when you sit down to go through your policy, because some of them can become very valuable and extend coverage to situations where there's not even damage at your property.
So as I mentioned before, it's really important to read the entire policy, read your entire policy in detail, front to back, including the endorsements. And those endorsements and the policy will describe the scope of coverage and extensions of coverage that Marshall was just discussing. An easy way, kind of a trick that we use when we're looking at insurance policies is to read the endorsements and then create an annotated policy. And the way to annotate your policy is to look at your first endorsement. Usually there's several in a policy. See, it will say which provision of the policy it modifies. Sometimes it will delete and exclude. It could delete an exclusion. It could modify an exclusion. It could add coverage to the policy. Look at what section of the policy it's modifying, and then go back to your policy form and indicate how that endorsement modifies that section of the policy. And so here's an example of how that would look. So if there's this tells me that there's an endorsement that somehow modifies the definition of advertisement. Maybe it adds to it. Maybe, well, that it looks like it doesn't delete it, because that would be what the second part of this, the second section of this graphic is illustrating, an endorsement that deletes or completely changes the definition of auto. So by making these annotations in your policy form, it will remind you how to make sure to go back and look at an endorsement, because it changes the form language in the policy.
Yeah, also, when you're looking at endorsements, pay careful attention to the lead-in language at the beginning of the endorsement. There's different wording formulations that are used in different endorsements and that they mean different things. So for example, a lot of times you'll find an endorsement that says, typically they'll say something generic like, this endorsement changes the terms of the policy. Please read it carefully, right? And it'll be in all caps or something like that. Other times it will say, paragraph 1A of the policy is deleted and replaced with the following, right? Now that means what it says, and it's different from other policies, endorsements that say paragraph 1A is revised as follows. It doesn't say deleted and replaced, but rather it has a more amorphous means of making an amendment to the policy. A lot of times, especially where you have policies that cover risks in different places around the country, or where you have, better said, you have insurance companies that sell insurance to policyholders that operate in different places around the country. You get these state amendatory endorsements that are attached to the back of a policy. Those are generally standard forms approved by insurance regulators in each state based on applications made to the insurance company, to the insurance regulators in those states. And they're basically designed to ensure compliance with the state-by-state regulations in each state. There's weird things happen though with these state amendatory endorsements. Sometimes the insurance company says in its state amendatory endorsements, that introductory language that I described earlier, the following endorsement changes the policy, right? Other times, insurance companies have an endorsement that says, the following endorsement changes the policy with respect to risks located in Colorado, right? Now, obviously, those two things have very different meanings. One changes the policy, period. The other changes the policy in a more limited way for risks located in a particular state. So it's important to pay careful attention to that prefatory language because they mean different things. All right, fire claims. So there's a couple of key provisions in a policy, like I talked about earlier. Typically, I'll look at the coverage grant, I'll look for exclusions, and I also want to understand how much coverage is available for the sorts of things that happen to this policyholder's business, right? So here's an example of some of the things that you might look at for a fire claim, right? The coverage for the building, damage to the building itself, coverage for the contents to the building. And this is common, very common in homeowners policies, and you see it in commercial insurance policies too. Typically, it covers both. Typically, it covers both subject to different sublimits, right? So you'll have coverage for X number of dollars for the repair and replacement of the building, and you have coverage for Y number of dollars for the value of the contents of the building. And then the next question, of course, is how do we value those things, right? If you have a brand new building or a brand new stereo, right? You bought it yesterday for X dollars. The fire happens the next day. It's still worth X dollars. If you have a building, though, that's 60 years old, and in need of repair, or a stereo that's 40 years old and that has a 8-track player and no one uses anymore, it's not worth the same amount as it was the day you bought it. Built into the concept of property insurance is the idea, historically, has been the idea that you can only insure the value of what you own. And that's the way historically insurance policies were written. But that's not really true today. Today, it's common for insurance policies to provide what's called replacement cost coverage. That is, even if I have a 50-year-old building that isn't worth what it was worth when I bought it, right? Or what it cost to build when I bought it. Let's say it's worth a lot less, or it costs a lot more to replace it. You can have replacement cost value coverage that covers you for the full cost of replacing the building that you had. So if my building was old and in need of repair, and I only could have sold it today for $275,000, maybe we should give a Boulder County reference, right? So if my building was old and in need of repair, and I could only sell it today for $1.5 million, right? But the cost of replacing what I had was going to cost me $2.25 million. A replacement cost policy will cover me for the $2.25 million number, even though the actual cash value of my building was less than that, right? So that's a valuable coverage. Other policies might only cover the actual cash value, right? And so how do we calculate these competing numbers, and how does it work? Typically, you calculate the replacement cost value of a property by, really detailed measurements of sheetrock and studs and beams and construction materials needed, and labor and overhead needed to rebuild what you had. Okay, that will give you a replacement cost value for a piece of property. Typically, the actual cash value is determined by taking that replacement cost value number and then ascertaining on a piece by piece basis in terms of the construction approach, what was the value today of that aspect of the construction project. The roof on the building, what is the lifespan of a roof? How old was my roof, and what was the actual cash value? And you depreciate on a unit by unit basis each element of the reconstruction project, and that will give you the actual cash value, right? So if all you have is actual cash value coverage, that's all you do. That you go through that process, and you can get paid the ACV. If what you have is replacement cost value coverage, the way it typically works is you do the analysis of what the replacement cost value is, you do the analysis what the actual cash value is, and the insurance company will pay you the actual cash value up front. You use that money to actually perform the repairs. And if and when the cost to do the repairs goes beyond the ACV, the insurance company will then pay you what's called the holdback. That is the difference between the ACV value and the RCV value, up to the full limits of coverage that are available for the replacement cost value. And that's typically the way it works under most property insurance policies. Now, that's true for homeowners. It's true for commercial as well. Business interruption claims, those are adjusted oftentimes with the assistance of a forensic accountant who will do a detailed calculation designed to accomplish what I mentioned earlier, right? To ascertain what would the business have done for itself had the loss not occurred. So typically you look at past performance as adjusted based on existing trends. If it's a new business and there isn't a track record of past performance, that's okay. There are ways of doing all sorts of estimates to ascertain with reasonable certainty, and that's the standard used in most states, to ascertain with reasonable certainty what the business performance would have been had the loss not occurred. So these are some of the things that you look for in the policy. Policies often provide sections that describe the specific way in which these losses are calculated. Forensic accountants can be really helpful in understanding the practical application of those terms. I've been involved in lots of disputes that involve, a detailed assessment of that sort of thing as well. And then a couple more points we've got on here: extra expense claims and claims preparation fees. Extra expense coverage, which is also very common in commercial property policies, covers you for the extra costs that are incurred to carry on your business in the wake of the loss, right? So if you've got to spend extra money to get inventory back in place to continue operations, and you've got to expedite things and pay extra shipping costs or pay more to replace your inventory than ordinarily you would, that's an extra expense. If you've got to pay overtime to employees to get things going again, if you've got a secure replacement location that goes above and beyond what your normal overhead is, that's an extra expense. Those types of things are typically covered under most commercial property policies. And last, claims preparation expenses. If you need to retain a forensic accounting firm or to assist you in putting together your claim, that type of thing is typically covered under most commercial property policies. The cost for attorneys or public adjusters usually is not covered. So that's kind of a summary of some key things there. We talked a little bit before about the all risk versus named peril coverages. There's a whole array of exclusions that may or may not be in your policy. It's really important to look at those carefully and look at the way in which they are framed. Some of those exclusions are framed really broadly, such as with anti-concurrent causation language, which is referenced here. That is, the policy will say, the following risks are not covered under this policy, whether caused directly, indirectly, or arising in any way relating to or happening concurrently with any other risks of loss suffered at the insured premises, something like that. The idea there is to capture and exclude losses where you've got a loss that involves fire, which is covered, and a loss that involves water, which is not covered. The idea being, if there's some sequence of events, one leading to the other, if the excluded loss plays a role in that chain of causation, the idea of these exclusions is to exclude that type of loss. There are some states where that type of really broad leading language is deemed unenforceable. That's not the case in Colorado. We cite a case here that held that these types of clauses are enforceable. But one caveat to that is the concept of you can't unspoil a rotten egg, right? The idea, and so a good example of this in the Marshall Fire context is if you have a property that's horribly damaged by fire, irreparably so, it's a total loss, and through the destructive mechanism of that fire, all sorts of pipes burst and water starts spewing out, and there's all sorts of water damage that results as well. If you have coverage for fire but exclusion for water damage, that exclusion for water damage, even though it's happening contemporaneously, would never do anything to change the total loss from fire that had already occurred before any water damage had occurred. So it's always been our position, and insurance companies usually accept this, that if the damage had occurred from a covered peril prior to the happening of contemporaneously and thereafter with the excluded peril, that excluded peril shouldn't restrict coverage, even with anti-concurrent causation language in the policy. There are lots of other formulations of exclusions that are narrower, right? So for example, this policy doesn't cover loss directly resulting from, or a little more broadly, directly or indirectly resulting from. There are also exclusions that exclude a certain condition of property itself. This policy does not cover settling, shrinkage, changes in taste or color. Those are not exclusions for loss resulting from that type of a thing, but rather it's an exclusion for that thing alone. So it's important to read these things carefully and understand the scope and intent behind each different type of exclusion. Limits and sublimits and deductibles. Really important to understanding the net value of the policy itself. You might have some amazing extension of coverage, but if it's subject to a very small sublimit, it turns out to not be that valuable to you. So usually the declarations page will reference the limits of the policy, and oftentimes the sublimits that are applicable to certain extensions of coverage as well. There's oftentimes also provisions that say, if you have coverage, if you have a claim or a loss that triggers multiple different types of extensions of coverage, we won't pay any more than the total limit of liability under this policy, And for any given triggered coverage, we'll pay only up to that particular sublimit. But typically you can put your loss into what we usually call buckets, right? So if you've got 90 days worth of coverage for civil authority, you figure out, well, how much of my loss is covered under the civil authority provision up to 90 days, and you put it into that bucket. If you've also got coverage for contingent business interruption with a sublimit of $5 million, you say, well, how much loss do I have? Not double counting, of course, the civil authority coverage losses, but is there other losses we've incurred that fit into my contingent business interruption coverage? Put those there, right? And you can fill those up separately. That's a sensible way of maximizing the value of what you paid for when you bought these types of policies. Deductibles are important too. With respect to fire losses that we're talking about here, there's usually no particular different deductibles that apply to fire losses. They're fairly straightforward and basic types of losses that typically trigger coverage under the main limit of liability under the policy. All right. Moving right along to notice, some of the conditions that Carrie talked about earlier.
So notice and time periods. Very important is to give notice of your claim and to give notice promptly. And here we say, be sure that notice has been given to all possibly relevant insurance companies. In a situation with a fire loss, I mean, it may be unlikely that there are multiple insurance policies that are going to come into play unless a business has a number of insurance policies that provide kind of like a tower of coverage with excess coverage as well. And then another time period to be aware of is that many property policies require a policyholder to file a sworn proof of loss within a certain time period of the loss having occurred, or from the date that the insurance company requests that the policyholder file the proof of loss. And here some examples of that time period could be as short as 30 days. So it's important to read the policy and to understand if there is a time limit in which a proof of loss is to be filed. Typically, a proof of loss is a form that's provided by the insurance company that's filled out by the policyholder or the policyholder's adjuster and notarized, signed and notarized. And it sets forth the amount of loss that's being claimed. So insurance companies have argued that the failure to file proof of loss forfeits insurance coverage. That is something that is not necessarily the rule in every state. So it's important to review the law, but certainly review the law in your jurisdiction. But certainly it's better not to be faced with that argument. So better to read the policy and comply with the time limitation in the policy, or write to the insurance company and request an extension of that time period and confirm that extension in writing.
Those provisions vary too. Sometimes it's a certain amount of time from the date of loss. Sometimes it's a certain amount of time from the request by the insurance company. Sometimes it's a certain amount of time there's a lot of variety there. So like Carrie said, looking at your policy is critical.
Right, and continue with the notice and time period discussion. Other time periods in a property policy that policyholders should be aware of are: a policy may contain a suit limitation provision, and that's separate from this proof of loss requirement. Some policies contain provisions that say that if there's a lawsuit, if you're unable to resolve a dispute concerning the payment of a claim, that a lawsuit must be filed within 1 year or even 2 years after the loss. And that period may be shorter than the applicable statute of limitations. So in Colorado, for example, the statute of limitations that would apply to a claim for breach of an insurance policy is 3 years. So a 1 or 2 year contractual suit limitation period is shorter than that time period. And a policyholder should be aware that they would need to comply with the suit limitation period in the policy. There is an exception to that under Colorado law for homeowners insurance. The Colorado Homeowners Insurance Reform Act of 2013 prohibits insurance policies from containing suit limitations clauses that provide for shorter limitations period than the applicable statute of limitations. So that means in a homeowner's policy, a policyholder would have 3 years to file a lawsuit, even if the policy purports to contain a shorter limitations period. It's also important for policyholders to be aware that a different statute of limitations applies to bad faith claims. Under Colorado law, there's a both common law bad faith claim and a statutory bad faith claim. Both of those claims have 2-year statute of limitations periods. So if as a policyholder, you wanted to make sure to preserve your right to file a bad faith claim, you would need to file your claim within 2 years instead of 3 years, which is just the statute of limitations for the breach of contract action. Or you could obtain a tolling agreement with the insurance company, which says that the parties agree to toll or suspend the statute of limitations while they're trying to resolve disputes concerning the claim. And in that way, you would have additional time to file a lawsuit. Policies sometimes also contain appraisal clauses, which is a form of alternative dispute resolution that can be used to determine the amount of loss or the value of property in the event there's a dispute over one of those issues. Usually an appraisal clause will permit the insurance company or the policyholder to demand an appraisal. Appraisers generally must be impartial, and they work together to determine the amount of the loss. Usually the policyholder will select an appraiser, the insurance company will select an appraiser, and then those two individuals will select an umpire. And together they will determine the amount of the loss. Some appraisal provisions require that the policyholder or the insurance company demand an appraisal within a specific time period. So it's important to look at your policy to determine if there is a time limitation for appraisal. Another a statute that was, or a regulation that was recently passed and went into effect on January 7th of 2022 is Emergency Regulation 22E01, which impacts time limitation periods in insurance policies in the event of quote catastrophic disasters, which would apply to the Marshall Fire, but is defined in the statute. And that regulation specifies that insurance companies shall waive waiting periods related to additional living expense benefits. And essentially waiting periods are deductibles when it comes to obtaining coverage for things like business interruption loss, that you may have to wait for 2 days, 3 days, a week before you can claim coverage for your loss. And that is similar to a deductible. The regulation also specifies that insurance companies should toll time limitations for additional living expenses and time limitations for repairing and replacing property where the insurance company causes unreasonable delay in settling the claim. So that's an important regulation for policyholders to be aware of and to use to get claims paid on a timely basis. Two other points to be aware of with respect to notice and time periods in policies is that some policies may contain a time period in which the policyholder has to tell the insurance company whether they are electing to repair or replace their property in order to obtain that coverage. And Marshall discussed before the difference between replacement cost coverage and actual cash value, and how replacement cost coverage is typically higher than actual cash value. So it's important, it would be important for a policyholder to comply with that timeline so that they're not facing any kind of dispute with respect to whether the higher replacement cost coverage would apply to the claim.
Another aspect of the replacement that we didn't mention, but I'll mention it now, is replacing elsewhere. Most policies have a provision that allow the policyholder to use the insurance proceeds to rebuild the lost property somewhere else. It's also the case under many commercial property policies that you don't even have to rebuild the same type of thing that you had. If you had, and typically if there's unplanned capital improvements that you decide to make to put the insurance proceeds to good use, that you can use the insurance proceeds to make those capital improvements, even if you're not replacing the particular structure or property that was damaged, right? So if you've got a business that has 3 different arms, and after this devastating fire, you decide, you know what, we're not going to really pursue that type of business, that aspect of our business anymore, but we are going to use that money to make capital improvements with respect to one of the other aspects of our business. Most policies will allow for that. That's not intuitive, so it's important to keep that in mind and worth looking at your policy to see the permissive uses in terms of replacement of damaged property and locations where you can do it. But it's common that you can do it in another location. You don't have to rebuild what you had in the same place. You get money to rebuild what you had with like kind and quality, but you can do it elsewhere. So what do you do in the immediate aftermath of the loss? A lot of you who are involved with losses, whether it be homeowners or commercial from the Marshall Fire, probably got phone calls from public adjusters or have people at your door saying, we want to help you work up the loss. And it can be it's a very difficult and trying time for individuals and businesses in the wake of a catastrophe like this. And it's hard to make sense of what the right way to proceed is. You also get contacted by independent adjusters who are there to represent the insurance companies. So I just want to unpack that language for a second, because I've always found it really confusing. A public adjuster is someone who represents the policyholder. They're experienced in putting together complicated property insurance losses and business interruption claims, and they are advocates for the policyholder in understanding the coverage that's provided and in getting a return for the policyholder of what they're entitled to under the policy. Typically, they work, however, on a percentage basis. They end up collecting as a fee a percentage of the recovery on the insurance claim. The key and they can be very valuable in doing what they do because they understand how this process works. They also understand where to look in policies for coverage that exists for different kinds of losses. The key is figuring out how to discern who's a good, reputable public adjuster from someone else, because they all kind of operate in this very kind of competitive environment where they descend when there's a catastrophe, they descend on the scene, and it's hard to tell. We've for years worked with lots of different public adjusters all around the country and have experience with a lot of them all around the country. And so that I'd be happy to talk to anyone to help kind of sort out public adjuster questions. The independent adjuster is a misnomer. They work for the insurance company. They're not really independent. They get paid by the insurance company to do adjusting services on behalf of the insurance company, which isn't to say that they're unfair, but that they have a side in this as well. So it's important to keep those two sides straight in your head as to who's who and who works for whom. So what do you do? So you want to get a team in place that you want to do what we've said already, which is understand what your policy says, right? You want a team in place that understands the rebuilding and recovery process. That may well include a public adjuster. If you've got risk managers, on staff, then they're obviously indispensable for this type of thing. And you want to take steps to move the process along that gets your business up and running again, but also honors your obligations to the insurance company to make sure the insurance company is in the loop and on board and supportive of everything that you're doing and that you're meeting deadlines. So, one, you want to protect property from further loss and mitigate damages. Mitigating damages means not just protecting undamaged property, but also protecting the ongoing affairs and revenue stream from your business, right? If there's, like I said, you have extra expense coverage to kind of keep things running as best you can in the wake of a loss. So you want to take those steps to do that as best you can. That's going to mitigate your business interruption loss. You want to get people in place that are going to do the repair and remediation work that you need to do. And especially with a horrible catastrophe like the Marshall Fire, those people are in short supply. Usually most communities see an influx of specialists who do remediation repair work. But still, there's oftentimes a shortage of labor, shortage of materials. So it's critical to have people doing what needs to be done to get work done for your home, for your business. And third, you want to document all of this, right? You want to be able to show the insurance company exactly what you did, what you paid, why you paid it, who you paid it to, how much it costs. Because insurance companies are well known for demanding backup and proof for everything that you've done. They're not going to pay for things if you can't show what you did, how much it cost, and why you did it. Similarly, in documenting the damage, photos are good, videos are good, whatever you can reasonably do to document what's happened, that's great. Having photos and videos of what things looked like beforehand is important as well. Like I said, you have coverage for replacing with like, kind, and quality. It's really convenient to have photos that showed the type and quality of the materials that made up your building or its contents before the loss. And then last and importantly, as I said before, the insurance company should be your partner in doing all of this. They should be supporting you in reimbursing all of the costs that are involved in recovering from these types of catastrophes. And as with any partner, it's important to keep them up to date. Insurance companies don't like surprises. So it's in your interest and the insurance company's interest that you're working side by side and communicating clearly about what's happening next, what does it cost, who's doing it. That goes as well for disposing of damaged property. A lot of times insurance companies want to inspect the loss. They want to see what it looks like. So before you get rid of equipment that's been badly damaged in the property, give the insurance company a chance to come and take a look at it, take photographs of it, document what you have. Be careful of situations where property is disposed of before the insurance company had a chance to take a look at it. All right, wrapping up, some more Colorado law info, which is really important. Carrie's going to talk a little bit about bad faith. Colorado's got some very favorable law on bad faith.
Right. Yeah. So thanks, Marshall. So for policyholders in Colorado, if the insurance company unreasonably delays or denies payment of a covered claim without a reasonable basis, there's a statute that provides redress for the policyholder. And that statute is listed here in the on our slide here. And essentially, if as I mentioned before, there's a 2-year statute of limitations to bring a claim under the statute. And if the policyholder demonstrates that the insurance company unreasonably delayed or denied in the payment of a claim, the policyholder can recover twice the amount of the covered claim under the statute, plus an award of attorney's fees. In contrast, or an additional claim, bad faith claim that a policyholder could bring is a common law bad faith claim, which requires has a slightly higher burden of proof. For the common law bad faith in Colorado, the policyholder must show that the insurance company knowingly or recklessly disregarded the validity of the policyholder's claim. And then if the policyholder meets that burden, they could claim as damages, whatever damages, consequential damages are flowing from the bad faith committed by the insurance company. And as we note here, the basis for common law bad faith in Colorado is the special nature of the insurance contract and the relationship that exists between the insurer and the insured. It's important to note bad faith law in Colorado because not every state has bad faith, common law bad faith, or a bad faith statute. And so it's important that policyholders be aware of this while prosecuting an insurance claim. And it can be an important tool to use to facilitate payment of the claim if it appears that there's a valid claim and the insurance company is unreasonably delaying payment. Another statute that we noted here pertaining to wildfires is a statute that prohibits insurance companies from refusing to renew fire insurance policies for property within a wildfire disaster area. So that's important for policyholders who may have been impacted by the Marshall Fire. If they're looking, they're coming up on a policy renewal and having challenges with obtaining insurance coverage. So that gives you a brief overview of Colorado bad faith law. We're coming to the end of our presentation. We've been happy to present to you today and encourage you to reach out to us if you have any questions about anything that we've discussed during our presentation. And thank you.
Yeah, hopefully this helps. Carrie and I are both admitted in Colorado, and so we field questions all the time about issues like the ones that people are experiencing, unfortunately, in responding to this terrible fire. So anyone who has questions, definitely feel free to reach out anytime. We'd be happy to talk.